day, Glemery.
Good day.
Ms. Speaker, you say that the proposition is practicable. That is correct.
Yes.
And when we say it's practicable, that means it's viable, it's lawful, it's constitutional. We both agree on that. Ms. Speaker, it is in your speech that the appointment was void ab initio due to
Yes.
ineligibility. But you would agree with me that her appointment was made through the nomination of the JBC and no less than the President himself.
Yes, but that,
Yes or
that
no,
means a
Ms.
great abuse of
Glemery, yes
discretion
or
on
no,
the part
Ms.
of the
Glemery, you'll
GBC
have your time
because
later.
there was
I'm
a
sorry.
violation of their own
Ms. Glemery,
rules.
let's proceed. But it is in your position that such appointment was invalid, correct?
Yes.
That's the very reason why we are here, because we are
Yes.
talking about co-warrant ineligibility. Do you know what political question means?
Yes.
It's settled in our constitutional law.
Yes, yes.
You would agree with me that generally judicial review is not available when it comes to a purely political question unless there is grave abuse of
Yes,
discretion.
but this
Of
is
course,
a
you said that in your
justiciable question, yes.
And that is merely speculative. We have to determine yet that
That's why
Ms.
the
Glemery.
Supreme Court
Ms.
can
Speaker,
determine
Ms.
if there's
Speaker,
grave
Ms.
abuse of
Speaker, let's
discretion.
proceed.
Because
You
it
would
is
agree with
apparent
me,
in this
Mrs.
case,
Speaker,
Mr. Speaker,
that there
it's
is
very blatant.
grave are you saying that there is grave abuse of discretion on the part of the JBC?
Yes,
instead of the
because they
President?
violated
Then
their own
that's not part of the wrong
requirements.
thing,
They were the ones who
Glemery. This is
expressly
not the proper
provided
forum
for
because
those
co-warranto
requirements.
is
But
not the proper
however,
case.
they shortlisted
Let's move on,
Sereno.
Mrs. Speaker.
Okay.
Please respect my time.
Okay, I'm sorry.
Mrs. Speaker, Section 2, Article 11 provides who are the impeachable officers. That's right.
Yes.
And you would agree with me that impeachable officers are also subject to co-warranto. That's your position.
Yes.
You would agree with me that a COMELEC chairman can be ousted. That's right?
Yes.
You would agree with me? Are you aware of the case of Nationalista Party versus De Vera?
Yes, okay.
And in that case, a COMELEC chairman was ousted through a co-warranto. That's correct? In that case. However, Mrs. Speaker, that in that case, the COMELEC chairman is not, it was decided under the 1935 Constitution, which is not under the 1987 Constitution, and hence, he is not a valid
All right,
subject of
Pedro.
co-warranto. Alright.
You've got 4 minutes now to rebut Glemery and advance your argument on why the proposition in this case is not practicable.
Your Honors, just point of rebuttals before I proceed with my constructive. First, the affirmative house would cite the Topacio versus Paredes. However, in Topacio versus Paredes, it arises from an election contest, even against an officer which is not impeachable. And there is substantial distinction between an elected one and an appointed. And here, no less than the Chief Justice herself. Secondly, they would say that it's cost-effective. But Your Honors, just because it's cost-effective doesn't mean we have to circumvent the law. What cannot be done directly should not be done indirectly, Your Honors. Now, proceeding on my speech. Your Honors, the proposition is not necessary as the Constitution provides for a mandatory procedure of removal from office of the Supreme Court Chief Justice. It is also not beneficial because this would create dangerous precedents that would create more constitutional ramifications. Now, onto my speech, it is not practicable as it is unconstitutional on two grounds. First, Supreme Court's jurisdiction over co-warranto does not include co-justices. Secondly, it violates the principle of separation of powers and of checks and balances. On to my first point, the judicial power of co-warranto is enshrined in Section 5, Article 8 of the Constitution. However, the same is limited by Section 11 of the same article, which provides the Supreme Court and Bank may remove only justices and judges of inferior courts. In the Castro versus JBC, the court held that constitutional provisions must be harmonized to give effect to each provision. Hence, to include the removal of a Supreme Court justice in a co-warranto is to expand such power which runs afoul to Section 11, Article 8 of the Constitution. Are we going to allow this, Your Honors? Such interpretation is nugatory and must be stricken out for being unconstitutional. Secondly, to grant the petition is to violate the separation of power and of checks and balances. In Angara versus Electoral Commission, separation of powers is a fundamental principle in the government, and it obtains not through express provision but by actual division in the Constitution. In this case, the power of Supreme Court over co-warranto in the Constitution is fleshed out in Rule 66 of the Rules of Court. To accept the theory of the opposite side that justices could be dismissed through its own rules is to delegate on the judiciary a power to remove and appoint, which violates the principle of separation of powers, which is the evil sought to be avoided by the Constitution in Noval versus Guray. The court held that in a co-warranto proceeding, the court determines who is legally appointed and ought to declare the person entitled to such office. Hence, assuming the court and bank could the Chief Justice, they ought to declare another person who is entitled to occupy the vacancy. This This, Your Honor, circumvents the Constitution, which expressly provides under Article 8 that it is the Judicial and Bar Council that nominates, and it is no less than the President of the Philippines that selects the appointee from the nominees. This is a purely political question which the court has no power of judicial review in the absence of a clear showing of grave abuse of discretion which has yet to be proven. Also, to grant the petition is to undermine the power of the legislative under Article 11 to have the sole power to remove impeachable officers, Your Honors. This is designed to uphold the power of checks and balances for a laudable purpose of constraining tyranny. Hence, such would trample the petition if this is granted. Your Honors, at this juncture in history, the Supreme Court, as the chosen guardian of the Constitution, should dismiss the petition for quo warranto as it has absolutely no basis in law and no basis in the Constitution. What can be done directly should not be done indirectly. It is but a mockery to the rule of law. And on that note, Your Honors, we in the negative bench strongly dissent. It is not necessary, not beneficial, and not practical.
2 minutes now for the cross-examination.
Good evening, Mr. Speaker.
Good evening.
It is your submission, correct, that the impeachable officers in Article 11, Section 2, should only be removed by impeachment?
Yes, of course.
Yes, but you are familiar with the grounds of impeachment?
Yes, of course.
Impeachment, isn't it that impeachment presumes a valid appointment on
Yes,
office?
of course, but,
yes, it
the
presumes
Constitution
a
did not
valid...
distinguish, and hence we
Excuse
should
me,
not
Mr.
distinguish,
Speaker.
Your Honors.
It presumes a valid assumption of office, correct?
Yes.
Valid holding.
The Constitution did not distinguish.
However, Mr. Speaker, this quo warranto proceeding precisely questions that the validity of
But
the
we have to
appointment.
reconcile
Correct, Your
Section
Honor.
5 and Section 8
Mr.
of
Speaker.
Article
Yes
8
or no,
of the
Mr.
Constitution,
Speaker.
Your Honors.
Next, if we follow your premise, then that means that the Constitution limits the means to remove these officials
Yes,
only
of course.
to impeachment.
That's the
Yes,
very purpose of the
but
Constitutional
if that's
Commission.
the case, there is no mechanism available
There
to
is
remove.
impeachment.
No, excuse me, to remove an a chief justice who is proved to be
Just
a
because
usurper.
that is not a viable
A
remedy
usurper.
doesn't mean we
There
have
are
to-
no.
to go for
Those
it
are
because
very
it's
different grounds,
unconstitutional.
Mr. Speaker. The impeachment is based on the premise that she was not usurping
Yes, I can
her
see that,
office.
Mrs.
Yes.
Speaker. However,
Therefore,
it's unconstitutional.
the correct remedy to oust a usurper is through quo warranto.
No, not necessarily, Mrs. Speaker, because that is
Next question, you are
unconstitutional.
familiar with Article 8, Section 8 of the Constitution?
course,
Yes.
of
So
course.
you know that the JBC was created under the supervision
Yes, of
the
course. That's
Supreme
why they
Court.
have the discretion.
And that means the Supreme Court can, by virtue of its power of supervision, inquire into the acts of the JBC.
Not necessarily if it's a political
especially,
question
Mr. Speaker, when
absent
there
a
is
great
a
abuse of
question on the
discretion.
validity of their acts, on the correctness
Not
and legality
necessarily.
of their
That is
acts.
speculative,
Correct, Your
Mr.
Honor.
Speaker.
You have read the cases of in-reappointments of Honorable Valenzuela, yes?
Yes, of
How about
course.
Hardileza versus Sereno,
Of
yes?
course.
Villanueva versus
Of course, and
Do you
those
know-
are not
so
in
you
point in
are
this case,
aware,
Mrs.
so you are
Speaker.
aware, Mr. Speaker, that in these cases, the Supreme Court emphasized that the JBC's exercise
No,
of
not
their
necessarily.
discretion
They
is
have
not
the discretion.
infallible, meaning
No.
they can actually commit errors.
No, they have the
They can
discretion to appoint
commit
and
grave abuse of
a discretion to
discretion.
nominate and a discretion to relax their rules.
Thank you, Mr. Speaker.
And with that, we end the debate proper. We now invite both sides to cross the House as our judges tally the scores. We'll bring you the results next. Please stay tuned. Square Off Season 15, the firm debate, will be right back. Let's now hear what our judges have to say about our debaters. Attorney Liu, how did the affirmative side, the Core Jesu College, do tonight?
The affirmative side was able to present well-supported arguments based on jurisprudence and precedents, despite taking unpopular side in this case.
And Attorney Cassis, how did the negative side, the University of Batangas, do?
The negative side actually did well-researched argument, and everything was based on law, the Constitution, the deliberations of the Constitutional Commission, as well as jurisprudence.
And so who won this round? We'll bring you the results next when Square Off, the firm debates, continues.
The busier your life,
square off the firm debates. Now let's hear from our chief adjudicator, Judge Dolores Espanyol. Your Honor, who did the judges pick for Best Speaker?
Okay, good afternoon, everybody. I am pleased to announce that the best speaker for today's debate is Mr. Bendrick Marali.
And the school that won this round?
And also, the score for this round goes to the highest scorer, which is the Batangas, the team for the negative side.
A big congratulations to the University of Batangas for winning the 5th elimination round of Season 15. Next week, De La Salle University and the St. Louis University will face off in Round 6. I'm Mike Yorata. Thank you for watching.